All right, thanks everybody. We are back. It's now 2 o'clock. We've got this 2-hour session to finish out our legal summit for this year. And the reason it's a 2-hour session, a double session, is because it's just been generating so much topic, so much content, so much discussion, so much back and forth that we decided that this needs a big chunk of our attention. So thanks for sticking around to the end of the summit. And we've got, first, we're going to have a part one, which is a presentation. And then followed by that, we will have invited commentaries and along with Q&A between the presenters and the commentators, as well as the audience as well. So remember as well that there's still up for grabs for the best question as voted by Laura Renfro. There is a copy in your chosen format of the last 2 years Legal Summit book. So our presenters today are Jeremy Horlick. Jeremy is Vice President of Business Development for ADA Site Compliance, a leading provider of web accessibility solutions for businesses. He works with clients across virtually every industry to help them make their websites, mobile apps, PDFs, and other digital assets compliant for those with disabilities. He specializes in finding practical and cost-effective strategies for companies of all sizes to stay ahead of the changing landscape of digital accessibility. Jason Taylor is Chief Strategist at ISL and advisor to the UsableNet CEO. He's a global technology leader for multi-channel customer engagement, actively advising leading companies on how to extend their, okay. All right, so just a programming note here. If you could just, we only need Richard, Jason, and Jeremy as the hosts. If you could make all the others not co-hosts, then maybe we won't have this problem of the recording stopping and starting. Okay. Are they okay with that, Denise? I hope so. Let's keep our fingers crossed because we need this recording. Okay, where was I? Jason, did I get to the end of Jason? Or did I just start?
Third paragraph.
Yeah, you were midway. Give Jason his due.
Midway, sorry. Jason Taylor, yeah, is an active member of the accessibility and usability communities since 2000, which started with leading partnerships between UsableNet, Adobe, and the Nielsen Norman Group. Richard Hunt is a board-certified civil trial lawyer with more than 35 years of trial experience in state and federal courts. At Hunt Huey PLLC, he has a national ADA and FHA consulting and defense practice. He speaks frequently on ADA and FHA accessibility issues to both national and local organizations. His blog, Accessibility Defense, serves as a national resource for hundreds of attorneys, accessibility experts, and others involved in this area. For the invited commentaries that will follow the presentation, the full bios are on the website. I'm not going to go over them here, but our commentaries are from Leonie Watson, who is director at Tetralogical in the UK, and thanks for joining us on a Friday night in the UK. Jared Smith is the associate director of WebAIM. Joseph De Niro is assistive technology specialist at the Helen Keller Services for the Blind. Andrew Nielsen, who you just met in the previous presentation, Director of Government-Wide Accessibility Program at GSA. And returning as well is Anil Lewis, as he is the Executive Director of the National Federation of the Blind Jernigan Institute.
And Chris, just really quick, Leonie does not have permission to turn on her video, so after we start the first part, make sure to address that, please.
Okay, we will make that fix. Okay, thank you very much. Okay, I'm going to hand it over now to Jeremy, I think. Yes.
Yes, I'm gonna thank you, Chris. Let me share my screen and just see first of all if everybody can see it. How's that?
Yep.
Great.
Awesome, great. Well, I realize it's a Friday afternoon, at least here on the East Coast of the U.S. So this is around the time people are going to start to flock to the bars. So maybe it's good that we're virtual and not in person in that respect. But certainly feel free to have a beverage of your own choosing while we speak. So thanks again, Chris, and to the team for having us today. I know that everybody here is really familiar with the overlay, the great overlay debate, as we're calling it. So we're gonna jump right in, and hopefully the remarks that we make today aren't too basic, too general for anybody here. I don't think they'll be too advanced. So we're just gonna dive in. And first, just a quick look at the agenda. Hang on, Chris, you popped up on my screen. I'm moving you to the side. Okay. So we're gonna spend the first 45 minutes or so talking about a quick overview of how overlays and widgets work, how they're constructed, and then we're going to look briefly at why companies are using these, why they should be avoiding these, and then alternate ways to address accessibility. We'll close up with a list of some resources for further reading and take some questions before we pivot into part 2 of the session with our five invited guests. So to begin, I thought it would be helpful if Jason unpacked a bit about how websites are constructed. That will be instructive on how we talk about overlays and widgets in this conversation. So Jason, did you want to kick us off here?
Yeah, thanks, Jeremy. Yes, the idea here is just to give you, if we've got lawyers on, or if people are watching this after it's a little bit less technical, I want to tie this also to lawsuits, so you understand. If you've looked at an ADA lawsuit, which there's lots of them, there's a range of technical terms that are used in those lawsuits. So understanding sort of the basic 3 layers of how a website's constructed and how that's done, I think will help people understand from a lawsuit point of view, what are they seeing in a lawsuit in terms of from a technical point of view. So hopefully this isn't too basic, but I really want to just get people's understanding that there's sort of 3 layers, and I'll connect them together. So you start with basically control and view, and that's typically delivered in the coding world using a cascading style sheet, a CSS. And that style sheet sets what the page or the website looks like. Its colors, its color contrast, its fonts, its font sizes. So if you look at some of these lawsuits that are filed, you'll find people talking about poor color contrast, for example. So that's the sort of the first layer in terms of what you see when you first come to a website. The second is basically where components that are for identification and organization. These are really important components of a web page or a website. They're really important, especially for people who are using screen readers, because they identify objects and tell people what those objects are. They're typically described in code as HTML elements. So that's a label, what the label is called. It's an image, what the image description is. So essentially, these are very important components that help organize a page, help someone get an orientation of where they are on the page and what they need to do on a page or a step of a website. The third component are interactions and functionality. Now, depending on the type of website you could have a website that's built primarily with 1 and 2, because it's primarily a content-only site with maybe a few forms for contacting us. If you're a small, let's say, dental surgery, you're going to have a website that's mostly constructed with items from 1 and 2. The bigger the company gets and the more important the website is for most companies, the more level 3 becomes important. And level 3 is about using a website. It's about creating functionality. And this is typically written in what I would class as sort of the cool stuff, the hard stuff. Is what people pay a lot of money for at the sort of high end of the business market. It's typically written in things like Vue.js and Angular.js or HTML5. The way that you as a user typically find them is you might see them as components or things that you do on a site. So for example, a seat map selection on an airline site, that's a component that's been built in a a high sort of level code like Angular.js. So websites use components for doing things like adding to cart, picking payments, sending to delivery. So a website is these sort of 3 layers. Now let's go and match that up with how overlays and widgets work. So maybe if you can move to the next slide, Jeremy.
This one or do you want the following?
So we're sort of grouping together solutions that are either marketed as Accessibly widgets or overlays. I believe they all work very similar in the fact that they all require a client to add a line of code on their website. So basically a JavaScript file is added to every single page of a website. It does 3 main things which they're trying to achieve. One, it adds an icon that most people have recognized is typically seen as either the universal human with the arms spread out, some type of icon that when you click on it, it opens up and it gives you a control panel. That control panel allows you to change things like font, color, contrast. So that's the first level. So it's helping somebody control the first level of a website. The second thing that JavaScript file does is it makes a call to the vendor server and says, do you have any updates for my HTML elements for this page? It means, do you have any changes to the alt tags, the labels, the form elements? Okay. Those updates are focused on essentially things that most overlay and widget vendors can find automatically. And you'll hear lots of sort of rumors about automatically can only find 20 or 30% of issues. The main problem with that call is that if it's not being checked, the quality of what's giving back, then you could potentially be putting alt tags or labels which are inappropriate for the particular field. And we'll talk about that just secondly. But in fact, it is updating code. So the first one adds a control. That's not updating code. The second one is updating code. It updates HTML elements. What it does is it can actually change a website that gets some bad testing from automatic tools like Wave or Lighthouse into a site that gets a lot better score from places like Wave and Lighthouse. And we might talk, so some of the other panelists might talk about this sort of, one of the issues that we have in accessibility is people's reliance on automatic testing, but we can talk about it as a second level. But that's what they're trying to do there. They're trying to update that HTML element layer and give as best possible score to auto detection as possible, okay? And the third thing they do is they add in somewhere some type of accessibility statement, okay? The vendors that we're putting in here, the ones which are most active are Accessibly, AudioEye, EqualWeb, User First and Userway. They do act differently. They're not all the same. And I'll sort of try to do that with this. I'll try to do that by pulling out some sort of comparisons on this next chart, Jeremy.
There you go. So
this chart is again trying to sort of simplify the world. On the left-hand side, we have those levels. Okay, so we've got control and view, which is the cascading style sheet. We've got organize and then identify, which are the HTML elements, and we got level 3, which is functional and interactions, which are essentially components, user behavior, things that people do on a website. So the tricky thing here is understanding how do you find issues in that layer, and how does an overlay try to address it compared to a traditional approach. And I say traditional approach meaning when you go to most accessibility consultants, most advocates, they say, you should change the code. You should change the code at the code level and give everybody the same code. So what are overlays doing differently than that approach? So the first one is level 1, control and view. Technically, most of its issues can be identified using some type of testing, okay? The way that the widget and overlay solve that problem, again, is not by changing the CSS, but giving you that nice looking control panel that allows you to control color, font size. The difference is that that means there's a technology layer between the website and the assistive user's device, where in the traditional approach, you would update the CSS and everybody gets the same CSS, which means the assistive user, the regular user gets the same code. There is no additional layer of technology. The second level, which is organize and identify, which is the HTML elements. Again, most HTML elements can be found to be missing by automatic tools, but not easily defined whether they're correct, equivalent, for example. So typically these HTML elements need some type of QA element. And I said to you before, these widgets and overlays make a call to get that better piece of code, right, from their server. In some cases, like Accessibly, they rely on AI to determine whether that code is good. Some others, like AudioEye and UserWay, have a human that does some QA on that callback in terms of it checks the labels, checks the alt text, makes sure that they are equivalent. That's quite similar to how you would fix it in the code. When you fix it in the traditional approach, you are updating the HTML elements. In that case, overlays and widgets are doing for that layer a very similar job. Lastly, on the components and functions, this is the hard stuff. Big caveat here, lots of websites don't have a lot of this, right? A lot of websites are built off CMS. I mean, millions of websites are built off CMS. They don't have functionality. So potentially solving level 1 and level 2 could potentially be a nice approach for some people, okay? There's advocates who don't like the additional technology that sits between the assistive technology and the website. But the approach could be argued for simple content sites, millions of them out there. This could be an approach that works. But for sites where people really need to do stuff, that's built in components. Components have to be tested manually. You need to test that there's no keyboard traps. You need to test with a screen reader to make sure if the page is updated, the screen reader's alerted to the update. So the testing has to be done manually and the fix has to be done in code. The component needs to be rewritten. That requires you to rewrite the AngularJS or rewrite the Vue. Overlays and widgets today don't fix components. Some try to throw in another little control panel, maybe to help out with navigation, but they don't fix the underlying component issue. But again, to be caveat, if you look at how many US companies are out there today, we're talking about 2.5 million companies in the United States. About 2 million of those use a website which doesn't have a lot of components, doesn't have a lot of functionality and interaction. So a lot of the confusions over where are the right possible uses of this technology, because it can't help every site and it really doesn't help the sites where people really need to do things like banking, insurance, employment sites, Salesforce, anything to do with real functionality. These solutions fall down on a technical front.
Okay. So Jason, that number you just threw out there is fascinating. So I didn't know there are 2.5 million companies and 2 million of them have minimal complexity that requires user interaction. So that means there's still what, half a million companies in the US at least that do have that. And your company and ours, we both track these lawsuits very closely. I think we both track every suit that gets filed under Title III in federal court, as well as many of the state jurisdictions as well. So if you and I agree that they're going to be on the order of 4,000 or so lawsuits this year, at least in federal court, that's a pretty small percentage of the total universe of companies out there that could be hit with a Title III lawsuit.
Yeah, it's an argument I think Richard would probably have his opinion on.
Sure.
A small number of companies are being sort of targeted, where the rest of the world is getting away with not doing as much. They're sort of taking the burden of the lawsuits. Maybe Richard will bring some of that in, I'm sure, when he starts talking about some of these lawsuits.
Well, I'm going to turn it over to Richard here. I wanted to just speak to the first point here about why so many companies are using widgets and overlays. And like you, Jason, I do lump them in together. I recognize that semantically, definitionally, there are differences between overlays and widgets, but we all sort of use them interchangeably. I think they're compelling really for their ease and their relative low cost. Again, Richard can speak more to this, but I always liken it a bit to any sort of 24/7 service that you sign up for. There's a certain appeal in knowing that somebody is paying attention while you sleep. You see home security companies do this, of course. More and more wealth management companies talk about 24/7 portfolio management and rebalancing. So it's the fact that somebody is ostensibly looking out for you while you're doing other more important things like running your life or running your business. I think that has an innate appeal to a lot of customers, and they're sexy. When you call them up and you click on them, they expand. They usually have some kind of sound effect. They look to the uninitiated like they're really providing some real value. And we've just become so used to having these technological solutions in our lives that we feel like that's going to extend to this arena as well, when in fact that almost certainly is not the case. But Richard, let me turn over to you for a second about the limitations on some of the smaller companies that are being hit. Can you talk a little bit about that? And are you there, Richard? And if you're not there, I can speak to it, but maybe I'm the one who's on mute and everybody else is. Oh, there you are.
I was muted. I had So and let me speak to Jason's point as well, because when we talk about lawsuits, it's not a monolithic set of suits. We really have more or less 4 kinds of players in litigation. At what you might call the top, it depends on how you view these things. There are a relatively small number of sophisticated law firms with a lot of expertise. They tend to sue large companies because they demand large settlements and because they are they're attacking complicated websites. So this is a small number of firms. They do file a lot of lawsuits, but they generally file companies that they know will pay the kind of settlements they want to get. Below them are probably equivalent number of firms that have less technical expertise, less desire to litigate, generally located in California. They will sue smaller companies. They demand smaller settlements. Once again, they tend to target people they think can afford to pay them. They don't want to put people out of business, but they do file a lot of lawsuits as well. Below that, there's a very miscellaneous collection of what I think of as bottom feeders in the litigation world. These are law firms that have seen the business and seen what's possible to do. They file lawsuits typically with very little technical expertise. They generally don't have the ability to prosecute an ADA lawsuit, and they will settle very cheaply. They won't quit, but they will settle cheaply. And then below the bottom feeders are law firms that simply send out demand letters. Now, some of the more sophisticated firms send out demand letters as well. So when we talk about actual filed lawsuits, we're really only talking about the tip of the iceberg in terms of litigation-related activity. But there are firms that send out hundreds of demand letters, often to very small businesses, mom and pop businesses, with very simple websites, although the website may have a few issues at the HTML level. But these are groups that will settle for they want very small amounts of money. They're just going to send a letter, make a quick hit. There's at least one outfit that is operating something like a collection agency where they just have a bunch of people in a room making phone calls. So we're talking about a wide variety of lawsuits, and we're talking about a wide variety of companies because, as I said, there are people out there suing small businesses. They don't get as much attention and they don't file as sophisticated a lawsuit. But I have had many clients who got a demand letter saying that somebody wanted $8,000 because they had missing alt text or something of the sort. Their web developer, if they had one, probably built a website based on templates, doesn't even know how to make it accessible or fix accessibility problems. And those companies, and as well as larger companies, are looking for a quick fix. And so the overlays are very attractive. Somebody says that for so many dollars a month, we'll guarantee that your website is accessible. If you're a small business, that looks attractive. If you're a big business with a lot of websites, that can look attractive. I have one client that either operates or owns probably several thousand websites, and fixing them all with an overlay looks like a great solution. Also, this works both ways, but on the second point on this slide, because we don't have any regulatory definition of accessibility, it's easy for manufacturers of overlays and widgets to claim that they are making a website accessible. It would be hard to prove that they're not making it accessible, because accessibility is not a word that has a legal definition right now. And you do occasionally see claims about accessibility that will tout the fact that some courts have suggested that the WCAG standard is good enough, but that's a very small minority of courts. But the absence of an actual regulatory standard makes it possible to make claims that don't turn out to be true. The public is also generally not educated on software-based testing. And by the public, I include any business that is not large enough to have its own IT director, or that has IT problems that are unrelated to its website. So it's easy to tell small businesses you can fix a problem because they don't even understand how their website works.
Right.
Widget and overlay companies, as the slide points out, have been very aggressive in marketing their products, aggressive to the point, I think, sometimes of making false claims, but they're aggressive. And when you've got a large number of people who are looking for solutions, aggressive marketing is very effective for selling your product. And then finally, the last point is a particularly important one. I have never had a client in any ADA or FHA matter get a lawsuit or a demand letter from somebody who actually was a customer. The litigation business is entirely driven by law firms that create the lawsuits they need. They have real clients, but they generally create the lawsuits. As a result, any company that has not been sued yet, and out of 2.5 million companies with websites, only maybe 20,000 of them have been sued in the entire history of the ADA. But if you haven't been sued yet, you don't know anything about disability or accessibility because none of your customers have ever complained.
Right.
So we can go on to the next slide, Jeremy.
So if I could just jump in on a couple things. One, you define the public as companies that aren't big enough to have their own IT department. And I would just add to that, many companies that do have their own IT person or IT department are also similarly uneducated on what true accessibility and compliance means. Oftentimes they're just running in so many directions, and they have so many other mandates they're trying to fulfill that this mandate takes a back seat. And so, as you say, when push comes to shove and they are given a threat or demand, or they're served litigation, they're going to reach for what's shiny and what's right in front of them. And there's one very well-known company that spent $30 million or raised $30 million in their seed round. And as far as I can tell, it went almost all into marketing. Some of it, I'm sure they'll say, went into R&D. But that's a lot of money to be investing in marketing for something like this. So
no, that's a good point, Jeremy. And although we're all fascinated by websites, for most big companies, IT means internal operations IT. It doesn't mean the outward-facing website. So.
Fair enough.
It's not surprising that IT directors don't think about the website. That's one of the few problems they have, that they can just contract out to a third party and try to forget. So.
Sure. The other point I wanted to add is you mentioned what the 10,000 companies that have been sued. Jason and I have spoken about this offline in the past, and we put the number at about 10x or 20x that number as far as companies or entities that have been either threatened, sent a demand letter, et cetera. So I know here in Florida, for instance, there was one plaintiff's firm that sent out tens of thousands of demands to every realtor in the state of Florida. It seemed they all got them. My controls are right over the caption of the title of the slide: Why companies should avoid. Okay, well, so let me speak for a second on this one, if I may. There are 4 different bullets here, all of which have some sort of supporting evidence for the claim. The first one here is that widgets and overlays may not. I think initially we said they do not, but we hedged our language, and some overlays, as we've discussed, may have some marginal benefit in select use cases. For instance, people who are aging into their disability, if you have loved ones who are, or if oneself, if somebody's in their 70s or 80s and starting to lose vision, there is some evidence that font magnification can have a benefit. So we don't want to say that they don't, but this YouTube link here, and I'm happy to send this to any participants after the presentation, will show you what it's like to be stuck in a keyboard trap when you are using one of these overlays and you're trying desperately to get out of said keyboard trap. So the second bullet point here, really you should talk about this because it's about reducing litigation risk. So do overlays reduce litigation risk and expense?
Yeah, the answer to that is they absolutely do not. And there are 2 reasons why this is true. The first reason is simply because they don't actually fix websites. And in particular, they are unlikely to fix even every error in the HTML code layer. They may be quite good at it, but if you look hard enough, you will find a mistake. And this is partly because even good artificial intelligence isn't going to do a great job on labeling images, and simply because there are limits on what artificial intelligence can do, regardless of which layer of the website you're in. The other reason is because the law firms, not all the law firms, but many of the law firms that are in this area do not care whether the website is really accessible or not. Their desire is to find something that they can identify as an error, usually by measuring it against WCAG. And if they can find that error, they can file a lawsuit in good faith, remembering that their goal is to settle the lawsuit as soon as possible. The only thing they want to avoid is filing a lawsuit that's clearly in bad faith. And because websites are complicated, and because 100% accessibility, at least even as measured by WCAG, is impossible, they can always find a reason. So the widgets can't reduce litigation risk, both because of the goals of many of the law firms that are filing the lawsuits and sending the demand letters. The firms that send the demand letters are even worse, frankly. And also because of the limits of the AI itself in actually making a website accessible. The reference here, the source here, is actually about a new phenomenon, which is law firms that are seeking out websites with overlays or widgets and suing them because of the problems caused by the overlays and widgets.
Yes.
The Jehoda versus Upright Technologies is a case that was brought by a very sophisticated law firm working in this area. They have plenty of technical expertise, so it wasn't sort of a random shot. They knew what they were doing when they filed it. And I would say that at least for that law firm, and maybe for others as well, that little universal human shape in the lower right-hand corner of a web page is an invitation to get sued. It is not something that will deter a lawsuit.
Sure. So if I can just speak to that, in the cases that I track personally, every day in the morning, I get up, I have my cup of coffee and go on to Nexus and Pacer, and I start to look at who was sued overnight and go to the target website that's named in each of these lawsuits and actually look at it on the day that the suit is filed. Now, I can't tell you that happens every single morning, but I try to do it every day for the very reason that I want to see if the suit, if it didn't mention the overlay or widget expressly, if at least the suit was filed at the time that the overlay was active on the website. We know, and I know personally from having seen correspondence from the overlay companies, that their alibi is that none of our clients has ever been sued after using our widget or overlay. They've only bought our product after they have been sued. So this is why I will go to the website on the day that the suit is filed, take a screenshot of it next to, you know, the New York Times or Washington Post or whatever, and I'll have the day's date and I'll put them side by side so you can see that the overlay was active at the time that the suit was filed. Does that mean 100% of the time that was the case? No, I can't prove that. Is there a chance that the plaintiff gave notice 2 weeks earlier, and then the defendant went out, raced out, and bought an overlay and still got sued? Sure, but in 95% plus, I would say, of the cases, the plaintiff was looking at the website with the overlay enabled at the time they decided to file that lawsuit. And there are, in my estimation, about 8 different plaintiffs' attorneys right now that are actively filing litigation. And you can disagree. If you have better numbers, certainly offer them up. But I've seen at least 8 different plaintiffs/plaintiffs' counsel file litigation against companies that have widgets and overlays enabled. So this is a phenomenon that seems to be growing.
I just want to, Jeremy, I just wanted to call out a couple of things.
Sure.
People have done a lot of good work in this space. So, for example, Cargrove actually, has done a study of 30, I think 50 sites that used overlays, a very long document that's actually been attached to claims as part of ADA lawsuits. I just want to, recount exactly what Richard Hunt said. These law firms look to add things to lawsuits. So going back to my point about how things are done by widgets, the layers of a website, right? They look for issues in those 3 layers. Are there missing alt tags? Is the color contrast bad? Does the screen reader have an issue with one of the user journeys, for example? They'll document that, they'll put it into the lawsuit. The widget's just another thing they can list. You've probably seen it yourself, which is, yes, lots of companies are sued with overlays on their site at the time, but also lawsuits include a line item of there is an accessibility widget on this site and it causes a keyboard trap. And a lot of those suits include reference to things like Carl Grove's research on why that's the case. So I just wanted to call out because there's some really good documentation out there that people have put a lot of time and effort in generating that will help people who want to educate other people, as a document that they can use, which is, and it's all public record. It's all on the lawsuit, so they can share, openly because it's all public record.
Sure, that's a good addition, Jason. Thank you. If I can use that as a segue, just to jump to bullet 4 here. So Carl Groves is the one behind the overlay fact sheet. Now there have been, I believe, about 600 or so web accessibility professionals worldwide who have signed on to the overlay fact sheet, which details many of the issues, the problems that we see with widgets and overlays. So I invite anybody on the webinar here who has not already seen it to go to check out the fact sheet and maybe even become a signatory yourself. Let's jump over I want to touch on bullet 3 because we're going to talk about it in part 2 of our session today. I feel like the NFB is better situated to discuss this directly, but there have been some very prominent statements in the press recently citing concerns by activist and advocacy organizations about the use of overlays and widgets. So let's just tease that now. Suffice to say that there's been more than just the NFB statement. voicing concerns about the way companies treat people with disabilities. So I'm going to move on to the next slide here.
Hey, and Jeremy, real quick,
Sure.
Maybe for you, maybe for Richard, I don't know which one, but Sally Thune had a great question about, can you file a demand letter if you are not an attorney?
Richard.
Yes, anyone can send a demand letter, and anyone can file a lawsuit on their own behalf. A person who's not admitted to the bar can't file a lawsuit on someone else's behalf. But for example, an individual who had a disability and didn't like a website could send a demand letter on their own and even file their own lawsuit if they wanted to try to navigate the sometimes treacherous waters of the rules of civil procedure. But you can do it yourself. You can also file complaints with the Department of Justice for anything that arises under Title III of the ADA. DOJ is not speedy in dealing with those complaints, but they have an online complaint process.
Thank you. Thank you for that. I can tell you, before things fell off a bit in Florida after the most recent Winn-Dixie decision, which was a revision of the previous decision, there were quite a number of pro se plaintiffs that we saw on dockets here in the 11th. So, and I just want to throw one more number on there, because based on my own research, and I'm sure this is more or less in line with Jason's, if you look at the number of sites that have widgets and overlays enabled at the time the suits come in as a percentage of the total number of suits being filed, my number comes to about 20 to 25%. That's not an official number, that's a ballpark, but anywhere between a quarter to a fifth of the companies that are being sued right now have an overlay or widget on the site. So let's just move quickly through this. I don't want to spend a lot of time because I think our other panels have done a pretty good job talking about root causes or root fixes for inaccessibility. Obviously, fixing the source code is the way to make a site more accessible and more usable. There's some debate as to what that means and if fully accessible is even a legally meaningful term. But you want to engage your web agency. Ideally, if your web agency knows what they're doing, there's certainly web agencies that are in the same business that we're all in, and that is the business of not losing clients. So when their clients or customers come to them and say, are you making my website accessible? They say, well, sure. And they put a widget on there and they know that their customer doesn't know any better. So not all web agencies are built equally. Using already tested accessible web themes, that's great. We know that the WordPress themes that are out there are by and large, and the Shopify themes are not inherently accessible. So I always love it when a prospective client comes to us and says, we just bought this accessible theme, so we know our website is fully usable and we know we're compliant. So this is a frivolous lawsuit. Obviously, testing with blind users and tools, documenting results, that's a no-brainer. The accessibility statement, another no-brainer. A lot of times we see people, I think, overdo it in what they lard up into their statement. So in an attempt to show they're doing something, they list everything. They mention every success criterion under WCAG in the hopes that some prospective plaintiff will go, oh, these guys are clearly doing their job. I think less is more when it comes to an accessibility statement. Right? Have the phone number, have the email address on the statement, but also make sure you've trained your staff to point 5, because if your staff gets that call, they have to not refer the caller back to the website that caused the issue in the first place. Now the user is running in circles. So you want to make sure that customer service staff is trained, that there's a dedicated line that people are checking if there's a outgoing voice message on there, right? Someone's minding the shop. And then, do you want to speak to the final point before we go on to? I think we have one more slide here. Do you want to hit that last one? Go ahead.
Yeah, just briefly. And first, this may sound cynical, but the truth is most of the law firms, probably all of the law firms filing these lawsuits, determine whether they're going to file a lawsuit not by having a user test the lawsuit, but by running a software tool against it. More sophisticated firms use more sophisticated tools. But What that means is if you're going to fix your website, and you should fix it, you really can't mitigate litigation risk by fixing it, but what you can do is you can make it more useful to your customers, and you can comply with the spirit of the ADA. So those are good things to do. But when you're fixing your website, the first step is to fix it so that it shows up with no errors on a software tool. It won't be fixed, but it will be invisible to a plaintiff who's using that tool to look for somebody to sue. So start with the things that cause plaintiffs to file lawsuits. The second, I mentioned arbitration requirements, and there are other techniques as well. The reason ADA lawsuits, website lawsuits, are typically not litigated is because in most cases, the plaintiffs will settle for an amount that is just a little bit less than the cheapest defense you could possibly mount. So if it's going to cost you $20,000 in legal fees to mount a credible defense to the lawsuit, they will settle for a little bit less than that, and thus discouraging anyone from actually fighting back. Their leverage derives from the fact that it's expensive to litigate in federal court, and it's expensive to litigate in state court too, although not quite as expensive. Things like arbitration provisions, if they're enforceable, can help move to a venue where the cost of litigating is less expensive, and therefore there's a realistic opportunity to actually defend the case if you don't think it has merit. You never want to waste money defending cases that do have merit, but many ADA Title III website cases really don't have any merit, in the sense that they identify things that look like accessibility errors but have no real effect on the ability of a person with a disability to use the website. So there are some techniques to get to a place where it's cheap enough that you can afford to defend a case that has no merit. But that otherwise, you're just faced with, if you get sued, how do you get out of it as inexpensively as possible so you can focus on serving your customers?
Right. And just to bring it back around, it sounds like we're all in agreement that throwing a widget or an overlay up, while cheap and fast, is going to have diminishing returns, and to your point, might actually create more risk exposure for you, for those plaintiffs that are seeking out widgets and overlays.
Right.
So let's
go ahead.
I know we want to be mindful of the time. We have our invited guests to come on and speak. I'm not minding the chat, so I assume that somebody will jump in if there are questions that we haven't hit yet. There is a page here at the end of the deck that has additional resources. Many of these names will be familiar. Apologies to Carl, we left the S off his name. That's Carl Groves up there. But a lot of these names, are, as I said, are going to be well known to the people in this presentation. So email me, contact me if you would like a copy of the deck. I'm happy to send it. But that is
This is Chris, just to let you know on the questions. Questions from the audience we'll hold till after the commentaries. Yep.
Okay.
Yep.
Great. So do we want to pivot directly into the part two?
For sure. I think so. Directly in. Yep.
No bio break here.
No.
If I can get one last point in, just very quickly to Richard's point before about the sophistication of some of these litigants. I should also mention that in the private settlement agreements that I've seen recently, there have been one or two plaintiffs' attorneys who have expressly forbidden the use of certain overlays and widgets in the remediation of the defendant's website. So I just want to put that out there too. If that practice catches on, I believe we'll see more and more plaintiffs' counsel including that line in private settlement agreements.